cannot emphasize this strongly enough. The public must comment and should share this video or the Dear SA link to family members, because this bill will have, this act, once it's passed in its current form, will have a massive impact at 3 o'clock in the morning when they are terrified by an intruder.
New legislation will impact your ability to deal with trespassers on your property. Joining me to discuss the implications of this new piece of legislation is Advocate Stuart Hayward at the Johannesburg Bar. So, Stuart, the Unlawful Entry on Premises Bill is before Parliament and open for public comment. Could you tell us about some of the details that is proposed in this bill?
Just very briefly, on the 12th of August 2022, the Department of Justice and Constitutional Development gazetted via the Government Gazette a bill titled the Unlawful Entry onto Premises Bill, which in a nutshell serves to repeal the existing Trespass Act and do away with the statutory offence of trespass and introduce a statutory offence of unlawful entry onto the statute book.
Okay, so this could be a fairly technical procedural thing. Why should we be concerned with this legislation? What are some of the proposals then? Are there any alarm bells ringing for you?
The problem with the bill itself is that it appears to go too far in trying to, in repealing the Trespass Act. It goes too far in burdening private property owners and tenants on private property to inform intruders that they are trespassing. And if they fail to inform intruders and fail to, for example, inform the SAPS, who it appears from the bill are the only party that are allowed to arrest the unlawful occupiers or enterers, then there's a possibility that trespassers may be able to use a technical defense at their criminal trial to get off scot-free. Whereas with the Trespass Act, it was very simple. If you don't have permission and you are unlawfully on private premises, you are guilty of trespassing. So what the Department of Justice and Constitutional Development has done is attempted to address apartheid era legislation with a new statutory crime. But there are so many problems within the bill, David. And I think if I could just start by talking about the fact that an intruder on premises has the ability to rely on a technical defense that if they were not warned by the landowner or tenants that they were on private property, or there was no sign that that this is private property, they can rely on a technical defense in terms of the bill if they have an interest, a reasonable interest in and title in the premises. Now, David, this is obviously massively problematic, considering we've seen on numerous occasions that Julius Malema of the EFF and other left-wing organizations have tried to get their members to occupy vacant land. So we live in South Africa. We're living in a country with low literacy levels and a poor understanding of what the law is, which means that this technical defense could easily be interpreted to say that there may be an ancestral claim on the land that will give an intruder a way out. And in my opinion, David, a way out which is far too easy. Now, you can understand that this bill attempts to address the situation, say, in the rural areas where there is no boundary fence and somebody is collecting water and they walk onto a farmer's land, that under the Trespass Act, they would have been guilty of trespassing despite them not intending to do so. In terms of this bill, they are given a defense if they didn't know that this was private land, which is understandable. But the problem comes in urban areas, David, particularly people living in the suburbs, for example, with electric fences, David, where they would ordinarily rely on the security companies to make a citizen's arrest in terms of Section 43 of the Criminal Procedure Act, so that security companies can deliver intruders to the SAPS, and that is commonly how this works. There's a clause within the bill that appears, David, and this is the problem with drafting. It's not clear, but it appears that the SAPS is the only body that is allowed to arrest an unlawful intruder in this situation. So the question then is, if your security company does arrest an unlawful intruder on your property, what then happens in terms of that defense in court if the SAPS doesn't do this? And what makes things worse, David, in terms of the bill, is that it is not just the SAPS that must be informed by the landowner or the tenant, but it is a specific member of the SAPS that is authorized by the National Commissioner of Police. So does that mean that your local precinct is authorized to make this arrest? So there's a massive overcomplication of something that should be quite simple, David, and so the bill itself is understandable, but it needs to be chiseled, and that's why it's important that the public comment, so that the bill can be chiseled into a form that is digestible and usable for private landowners.
Yeah, this seems like a classic case of over-legislating, and I think there is a real oversight there in terms of, you know, not acknowledging really the undercapacity of the police to respond timeously to calls for assistance. So now, if you wake up at 3 o'clock in the morning and somebody's trying to gain entry into your property, call the police. There's no guarantee that they're going to be able to arrive. So it's very important that private security companies are empowered to make those arrests and to stop intruders. So let's get into this topic of potentially exonerating land invasions or providing legal cover in a way to land invasions. The bill does talk about if intruders have already erected any form of housing on the premises and already occupy the erected housing, the authorized member or members of the police, that is, must arrest them for unlawful entry on a premises. That doesn't mean that they cannot be evicted. Is that a fair reading? Yes,
David, that is a fair reading. They can be evicted. In terms of the PI Act, there must be that procedure must be followed. The PI Act itself protects residential occupation of land. David, you make a very important point in that sense, because there's a massive problem with vacant land in South Africa in terms of parties erecting houses and nobody knowing about it for days because the land is vacant. So the problem then comes in once again is that it's only the police that can arrest these parties that have erected these structures. I think the problem, David, is that, well, despite the fact that they can still be evicted and they can be arrested, that there are so many technical defenses in the bill available to these people. For example, if they didn't see the sign outside the premises that said that this is private property, because that is an obligation in terms of the bill, that land must be signposted, either signposted as being private and that entry is prohibited, or that a lawful occupier must warn these individuals that they are trespassing, and they must. And the worst part, David, and this applies to all land, is that somebody waking up at 3 o'clock in the morning cannot just immediately call their security company, because they first have to give the intruder an opportunity to leave the premises. Now, David, that is particularly galling in a country with this higher crime rate as South Africa, that you must give a party an opportunity to leave the premises before you are obliged, not a discretion, you are statutorily obliged to call the police. So there are so many technical defenses, David, that it's absolutely absurd. Because criminals in South Africa already abuse the numerous constitutional rights available to them in order to get off scot-free on technical defenses. Now, this just appears, David, and I may be reading too much into this, but sort of a more sinister measure by a left-leaning ANC government to not necessarily attack private property rights, but to make it more difficult for private property right enforcement. So making it more difficult for tenants and owners to protect their private property. So all these presumptions and obligations, David, make it an existing situation which is already onerous even more onerous.
All right, so Stuart, how can ordinary South Africans submit their concerns and influence the drafting of this legislation?
David, I'd recommend that ordinary South Africans place a comment on the Dear SA portal, which allows them to make comments which will be sent off in an email by Dear SA to the department. David, I just want to place the emphasis on the fact that South Africans must protect their sacred democratic right to comment on legislation. South Africa is the only country in Africa where public participation and pushback really works. If we don't get enough comments for poor bills, if there's not enough participation in democracy, we lose democracy. I cannot emphasize this strongly enough. The public must comment and should share this video or the Dear SA link to family members, because this bill will have, this act, once it's passed in its current form, will have a massive impact at 3 o'clock in the morning when they are terrified by an intruder.
Stuart Hayward, thank you very much. Let's hand over to you, our audience. Do you think that the unlawful entry on premises bill represents a threat to property owners? Leave your thoughts down in the comment section below. My name is David Ansara. This is the CRA. Until next time, take care.